You've probably heard that student loans can't be discharged in bankruptcy. For years, that's what most people thought. But here's the truth. They can be discharged if you meet a very specific legal standard. The problem is most people misunderstand what that standard really is. And if you get this wrong, it could cost you thousands in legal fees and years of false hope. In this video, I'm going to show you who actually qualifies for student loan discharge, and just as importantly, who doesn't, so you can make an informed decision before taking your next step. It's all about whether requiring you to pay your loans creates an undue hardship for you. Coming up in this video, I'm going to cover 3 critical points. First, what undue hardship actually means in real life, not just in legal language. Second, how courts decide whether your undue hardship is likely to continue far into the foreseeable future, or whether it's a temporary situation. And third, what it means to make a good faith effort to repay your loans, and why that one factor alone can make or break your case. These 3 points make up what's called the Brunner test, which is used by bankruptcy courts here in New Jersey and many other states. Once you understand this test, you'll have a much clearer idea of whether student loan discharge is realistic for you. Now, the Brunner test is like a door with 3 separate locks. And unless you can unlock all 3, that door doesn't open. Lock number 1, can you maintain even a minimal standard of living if you're forced to repay the loan? In other words, would payment be an undue hardship? Lock number 2, is your financial hardship likely to continue for a significant portion of the repayment period? Not just right now, but well into the foreseeable future. Lock number 3, have you made a genuine, good faith effort to repay the loans? Now, most people focus on just the first one, but courts require proof of all 3. If even one lock stays closed, the loans don't get discharged. Let's talk about the first lock, minimal standard of living. This doesn't mean living comfortably. It doesn't mean being stressed. It doesn't mean you can't go on vacation. It means that if you're forced to repay the loan, you wouldn't be able to maintain even a minimal standard of living. Courts look at your income, your necessary living expenses, whether you have dependents, your housing situation, and your employment status. As one court opinion put it, they're looking for a certainty of hopelessness. As you can imagine, this determination can be very subjective, and courts across the country have ruled in different ways. That's what makes this a lock that's very hard to open and can sometimes require that you prove you're almost starving to death in a rented room to qualify. Worse, even if you unlock the first lock, most cases are decided right here at lock number 2. The hardship has to be likely to continue for a significant portion of the repayment period. Not just this month, not just this year, not just because you had a setback. Temporary unemployment isn't enough. A short-term drop in income isn't enough. A brief financial struggle is not enough. Courts also look at earning capacity, not just current earnings. Your education matters. Your licenses matter. Your skills matter. Your prior higher income matters. For example, there was a case where a church pastor was earning very little, but he had degrees. He had prior higher paying experience. The court said he had the ability to earn more and was basically living below his earning potential. In another case, a debtor had a history of higher earnings but chose lower paying work. The court looked at that history. If the court believes you can reasonably improve your income, it may decide that your hardship is not persistent. And if it's not persistent, you don't unlock that second lock. Now, let's assume you've opened the first 2 locks. You're still not done. There's the third lock, good faith effort to repay. Courts want to see that you made a genuine good faith effort to repay your loans. They may look at your payment history, whether you tried to negotiate repayment plans, whether you considered income-driven repayment options, and whether you tried to maximize your income. Minimal payments may help your case, but no payments without explanation can hurt your case. Discharge is not granted simply because repayment is hard. It's reserved for people who tried and still can't succeed. Now, there's one more thing you need to understand. Student loan discharge does not happen automatically when you file bankruptcy. You have to file what's called an adversary proceeding, which is basically a lawsuit inside your bankruptcy case. That means additional legal work beyond the bankruptcy itself. Some bankruptcy attorneys charge a flat fee for the bankruptcy itself, others charge by the hour. But the adversary proceeding is usually handled separately from the filing of the bankruptcy petition. And that can result in additional fees. And many lawyers charge hourly for an adversary proceeding. Depending on the complexity of the case, that can amount to thousands of dollars in additional legal fees with no guarantee of success. So as you can see, this isn't something you want to guess at. Again, most states use the Brunner test, but not all do. So if you live outside New Jersey, you need to confirm whether your state applies the Brunner test or a different standard. If you live in Burlington, Camden, Gloucester, Salem, or Cumberland County here in New Jersey, and you're wondering whether you realistically qualify under the Brunner test, the next step isn't guessing, it's getting clarity. There's a link in the description below where you can schedule a call with me. We can get a consultation on the calendar to look at your situation, your income history, your repayment efforts, and whether pursuing discharge makes strategic sense in your case. Before you spend thousands of dollars trying to open those 3 locks in court, make sure you actually have the right keys.